matters because when lenders are suspicious, deals don't close. And lenders can review a deal right up to the minute of closing, and if they're a little bit suspicious about where the money came from for the deal, they can just cancel the loan. They don't care. And if the loan is canceled, we have to do an extension, the client has to find the money, and you may not get paid. So this matters, because you want to get paid on every deal. So the best way to avoid a problem is really know your clients. When I say know your clients, specifically buyers, what do I mean? I mean that you have to know how they are connected to your community. That's what the government cares about. Are these people connected to the community? Because if they're connected to the community, then they're not crooks who are looking to launder money. If you want a lesson in money laundering, just watch The Ozarks on Netflix, and you'll learn how to launder money. Okay, I also believe when you know your clients, it will lead to referrals and increased business, and I'm going to explain why. So, there's 2 questions you're going to ask anyone who contacts you today. Any or awesome. 2 questions. How did you find me? That's a very important question. 80% of the time, this satisfies Fintrac. Why? How did you find me? Well, my brother did a deal with you. My cousin did a deal with you. The guy I work with did a deal with you. You did a deal for my nephew. Right away, you make the connection between who's calling you and somebody else. 80% of the time, that's enough. You know this person is connected to the community. That's why that is such an important question. How did you find it? The next thing you always have to be thinking about is this: where is the money coming from? You always have to think about that. This person who's buying, where do they have the money from? In other words, does their employment and savings add up to what they're buying, or it doesn't make any sense? If it doesn't make any sense, it starts to look suspicious. It could be a gift from their parents. That's totally fine. As long as there is an explanation, where is the money coming from? So these are the 2 main things you have to be thinking about right away. So, when you go see a seller, Fintrac is not hard, because they're here, they're living here, they're connected to the community, they've been living in a home. It's not as complicated. But when a buyer calls you and you can't make the connection, you don't know who they are, I recommend that you send them a short email every time. And I've given you all the information in the handout. The email should contain 6 questions. It takes 5 minutes to fill out. If the buyer doesn't have 5 minutes, cancel the showings. They're wasting your time. So here are the 6 questions. Have you signed an agreement with another realtor? This will protect you in any arbitration against another buyer brokerage. You don't know if the client's lying when they tell you they have it or they haven't seen a property with another brokerage. If you get this in writing, you will win the arbitration. The second question is Fintrac. Can I please have your business contact information? This is not personal. Why is this important? The maybe most important box on the Fintrac form is the occupation. And right away you get it. You get what they do for a living right here. And so right away you have the means to fill out the occupation. A Fintrac auditor, that's what they care about. What does a person do for a living? How are they connected to the community? You just asked. From a selfish standpoint, you all know you're going to have to take this person to a mortgage broker, so you need to know if this person can qualify for a mortgage. They have a job, they can qualify for a mortgage. Then the next few questions: what are you looking for? What area and the price range? So if somebody put that in an email, I'll bet any one of you could do a CMA in about an hour or 2, and to show what's available for the show. And so you're as ready for this person as you are now for a listing. And the last question is, do you own a home? Because if the answer is yes, this makes the prospect much more appealing to you. So I'll stop here for a second. How many of you think this is a good idea, just to send this out? So do it. Start doing it today, and you'll save yourself a lot of time. and you'll be much more focused in getting these people the right house faster. Okay, now you want to build your relationship. And many of you take coaching. There's expensive coaching, realtors, etc. Most of the coaches will tell you that it takes a lot to get a new customer. You've got to spend a lot of money farming, meeting, networking to get a new customer. But it's not so hard to get a referral. And you've got to keep the referrals coming. So you've got to contact and stay in touch with your database. How many of you do that? How many of you contact your database at least once a year, maybe once every 6 months? How many of you have gotten deals by contacting your database? You just call to say hello and they say something like, oh, my nephew was looking for a house, I couldn't find your card, thank you for calling, I'll give you the name. How many of you have actually got business by just contacting your database? I'm telling you, it's there. If you're not contacting your database, you are losing money. So you should be doing this anyways. And when you speak to them, there are certain subjects you may want to talk about. Like, you're going to talk about their contact information. Can I update your email and telephone so I have all your proper contact information? Can I have your work information? Are you still doing the same job? Did you get a promotion? If somebody got a promotion, then maybe they can afford a little bit more money to trade up houses. So you see, just by asking these questions, you are building the relationship with the client. You're finding out more about them, and you maybe even have the opportunity to discuss, the market got a little softer now. Even though your house may be worth a little less, you can trade up for less money. This may be the perfect time to do it. So you see, not only are you building a relationship, by doing what I just said, this is what Fintrac means when they say monitoring. So we're going to talk about monitoring in a few minutes. Monitoring does not mean you run around with binoculars trying to see what people are doing. But it means that you are staying in touch and making sure that there's a good explanation for how somebody can buy multiple properties within a few years. Just that there's a legitimate explanation. So what are Fintrac's main goals? Is to stop money laundering. It's when people use cash, they may buy a bungalow, use cash to build the bungalow, and then flip the property in a resale deal. All that money comes out clean. So that's an example of money laundering in real estate. Many of you know that this brokerage will not take cash deposits, but that's just a small part of money laundering. Because as we'll see, every bank draft, as far as I'm concerned, is suspicious. Because it doesn't say who the money came from. It's just a bank draft with money on it. And the government is getting more and more suspicious about bank drafts. Now, I've seen some deals where the buyer has brought 2 bank drafts in order to make a deposit. So one from 2 different banks, that to the lender is money laundering. They need an explanation. Why did you bring 2 bank drafts from 2 different banks? Most of you wouldn't have thought that's money laundering. Somebody puts an offer today for $1 million with a $50,000 deposit. It has a home inspection condition. 3 days later, the buyer says, I'm not satisfied, I want a release. And they had a home inspection. Now, the broker of record is not going to write a check for $50,000 right away. He's going to make sure that the check clears first. But as far as the government is concerned, that could be money laundering. A bank draft for $50,000, we don't know where it comes from, but clean money comes out. And so many of you may not have thought that that was money laundering, but that could be an example of what the government thinks is money laundering. And so, how do you stop this? The government does not expect you to be a private detective. They've given everybody their own sort of measure of protection. Your banks have to do much more vetting than you do. People who manage money have to do much more than you do. What's your main job? Identify clients. That's it. That's what they're saying to you. They want you to personally identify somebody, face to face. Because to them, this is what you do. You meet clients face to face. And so as long as you're doing that, you're identifying somebody face to face, looking at their ID, that's what they want you to do. That's 95% of the way there. That's why the forms say, identified in person. And people ask me, how do I get picture ID? It's easy. Just say to everybody, we want to protect you. There's this 15% tax now that you have to pay if you're not a Canadian citizen or a permanent resident. And so, to protect you, we just need a picture of your passport. You see your passport, you're a Canadian citizen, you don't have to pay this 15% tax. And so that's an easy way to ask for a passport. And now you've got everything you need to identify someone. So that'll make it, I hope, easier for you. You're trying to protect a person by doing that. Multiple deposits, you're going to have to ask why. This could be a good explanation. One was my RRSP that I was cashing in order to buy the house, and the other is my regular account. As long as there is a good explanation, it's fine. You're not a detective. When somebody comes into my office and says this is their first home, I don't have to do an investigation. I just say, this is your first home? You've never owned a home? No. Sign here. And as long as they swear to me that they've never owned a home, they're entitled to the first-time buyer rebate. Now, they could be lying. The government sometimes audits this to check. But that's not my problem. My problem is I just got somebody to sign. That's what you have to do. Your problem is you've got to positively identify somebody. In person. That's your job. And if something is suspicious, they don't have identification. They're acting for somebody overseas who you've never met. Well, that's suspicious. And then you've got to go talk to Alana and decide, is this something you're going to report or not? So when they fixed up the form a few years ago, they included this section C. And C is to determine whether there is any risk. And you have to always complete it. But there's a box that says the client's in front of you. So if you put an X there that says, I identified this person in person, then it's automatic, low risk. And it's pretty simple. Do they have a connection to Canada? Do they have a Canadian bank account? That's all you gotta really determine with number C. Then we come to D, which is a business relationship. And so a business relationship means that somebody has done 2 deals, not with you personally, but with this brokerage, Spectrum, within the last 5 years. So it could be as simple as they bought a house 2 years ago, they're selling the house today to buy another one. That means they're in a business relationship with you. So every time there's a business relationship, you have to decide, is there a good explanation? Is there a good explanation for the business relationship? And most of the time there's an easy explanation, and that's what you put in section D. The explanation. They sold their house to buy another house. Simple explanation. But how many of you ask every new client, have you done a deal with our firm in the last 5 years? How many of you ask that of your buyers or sellers? Well, you have to start doing that right now. Because really, that is what they want you to do. And I think that's just a common question, like, have you done a deal with us before? Okay, so if the person has no job, they don't make any money, and they're buying a deal every year from this firm, through this firm, that's a little bit suspicious. Because it doesn't answer where is the money coming from. And so, in most cases, it is not suspicious. That's why you just write the reason in section D. So in my opinion, starting from today, every new client, Yolanda should send out a directive, every new client you ask, have you done a deal before with our firm in the last 5 years? And just write yes or no on the front of the form. So, what questions are you going to ask somebody if they say, yes, I have done a deal in the last 5 years? So, first question, where's the money coming from? Simple. I bought a house to sell another. I'm refinancing one house. I've increased the equity in my house, so I'm refinancing, taking money to buy an investment property. A lot of people do that. Their house value goes up, they invest with a line of credit, and buy another property. Could be a gift from the parents. These are all legitimate answers to where's the money coming from? And you just put that in section D. That's what they want. You don't need to follow people. It just, there has to be a logical explanation to answer the question, simple question, where did the money come from? And what are the reasons? See, the government likes long-term investments. Long-term investments means you intend the money to stay here, you're building for the future. Quick flips are suspicious. Quick flips means you put some money in, you're running away with it. This is why assignments are suspicious to the government. You have to be so careful with assignments. Just to be safe, I would make every assignment conditional on lawyer approval, because the rules are getting different every day. HST consequences are bad. People don't understand it. Trust me, do the agreement. Just make it conditional on lawyer review. It doesn't matter if you're acting for the seller or the buyer. Send it to a lawyer, get some advice. It doesn't take long for me to fix these things, and you'll be protected and your clients will be protected. So who's the Fintrac officer here? It's Alana Hurst. So Alana's the officer here, so if you ever have a question, you're not sure what to do, you contact Alana. Now, how many of you have read the company Fintrac policy? Yeah. Okay, if you haven't, it will be emailed to you, and you have to read it. And then you have to complete a training certificate that just says you read it. That's what the government wants you to do. They want you to at least understand the company Fintrac policy, and they make it so important that you all attend this update this morning with me to make sure that not only do you understand the policy, but you understand all the updates that have happened in the last couple of years, because things are changing as we speak. So, here are some simple policies that I'm sure are part of your policy that make a lot of sense that you're aware of. So you know you can't take a cash deposit unless you get approval of the compliance office. And how many of you take photocopy or a picture ID from the person? Okay, how many of you will ask for the ID and write down the information? Okay, both are legal, both work. Sometimes the client's uncomfortable with a picture, but if you're going to write it down, be very precise. Because when the government comes to audit, they literally open the computer and get online with, like, the Minister of Transportation. So if you've copied a driver's license, they will type in the number. If you made a mistake and it doesn't show up, that's a deficiency for the broker. This is why, where possible, I would try to get a picture. I would always try to get a picture, but sometimes you can't. So you got to be so careful when you are writing down the information to get it all clear. So I'm sure this is a policy here, no commission, unless you submit all the Fintrac documents. Because you can't get an agent to do anything unless you say no commission. And I'm sure that besides commission, you have to submit all the documentation, the BRA, all the customer or the working with a realtor documents. And the reason for this is not just to be exact. If you ever get a complaint from RICO, I sit on the RICO Education Committee. the first question they're going to ask you is, please send us all the paperwork from the file. And if you're careful, when you complete all the paperwork, they are much more likely to believe your story than to believe the customer who's complaining about you. And that's why it's so important. When your paperwork is not carefully completed, it's a mess, well then they're much more likely to believe the person complaining about you in your story. So it's very important that you develop the right habits and you get all the paperwork done. I had one fella who was acting for a seller and she didn't have any proper ID. She was elderly. We'll talk about that in a couple of minutes. He took her to Service Ontario. You know, at Service Ontario, you could get a ID card with your picture on it, just as an ID card. It's not a driver's license. And he sat with her for an hour and a half, and she got the card, and he put it in for Fintrac. And her daughter said to him, I can't believe you had the patience to sit with our mother for 90 minutes at Service Ontario. And he said, oh, I had a lovely time. P.S. He got 5 deals from that family. You know, he just went that extra step for Fintrac purposes. Okay, if there's a business relationship, now you've got to ask, how are you doing 2 or 3 deals in the last 5 years? And then write down the answer in section D. And I gave you examples of the answer. It's not hard. Selling a house to buy it. As long as there's a connect the dots explanation, you've done your job. If at any time in a deal, things start to look suspicious, then you have to go and speak to a lender. It could be at any time in the deal. May not be right away, could be part way through. Anytime it starts to look suspicious, you have to go speak to a lender. Okay, so when you review the ID, it cannot be a photocopy. You have to see the original passport, driver's license, permanent residence card. You can take a picture of it, you can copy down the information. If you're copying the information, you have to make sure you get all the information. So you want to make sure you copy the full client name, the type of card, is it a driver's license or a passport? Jurisdiction, if it's a driver's license, you put Ontario. Passport, Canada. The expiry date, that's the most important. You must put down the expiry date. If the expiry date expires before closing, the buyer will not get their mortgage. So you want to check the expiry date of the card as well. Then the date you do this. So if you do it today, you'll mark down March 27, and then you'll sign it. After June of last year, they developed a solution to help you with people who do not have picture ID. And this is typically elderly sellers whose passport has expired and they can't drive anymore. So they don't have picture ID. They have a health card, but you're not allowed to use a health card. And so for these people, there is another method to do ID. For everyone else, all you have to do is one picture ID, fill it out at the top of the form. You can ignore the rest of the identification requirements. Because remember, this was the #1 thing they want you to do, identify somebody in person. So let's say you have an elderly client. You can look at 2 other pieces of paper. I'm thinking an elderly seller who is selling their home. So the first document has to show their name and their address. The second, their name and birthday. And for most of you, that's what you're going to use. A third document, which I think they will be very reluctant to give you, is a bank check for a current bank account. Because many elderly people are suspicious and they will not want to give you a check. So what can you use to identify a seller that's legal? Here's the first, a utility bill. So just the gas bill, what does it have? Their name and address. Another great reason to have a gas bill is it'll tell you whether anything is being taken on payments. So besides the hot water tank, maybe they're renting the whole furnace and air conditioner. You can see that right away by studying the gas bill, and then hopefully you don't make a mistake when you do the listing. The second is a birth certificate or a marriage certificate. Both of these documents, and I find most sellers do have this. Even though there's no picture on it, they have this. So this will suffice. These two documents is enough to identify a seller if they don't have an up-to-date picture for you to look at. So again, you have to record everything. I would take a copy of the gas bill. Just take a copy and sign it. If they won't give you a copy, you have to write down the information, that it's a utility bill, Rogers cable bill, names, and the date you record the information. Most people will not have a problem with you taking a copy of these documents. For any of you about these slides, I will send these slides to Alana so she can pass them out to everybody. Most of your information is on the handout anyways. Is that okay? Okay. So now we come to the receipt of funds. So this is becoming more and more of an issue. Why? Because of the question, where did the money come from? So on the receipt of funds, that's what you have to ask somebody. Where is the money coming from, and where is it going to? Now, going to is easy, because in almost 90% of your deals, it's going to a listing broker. So all you have to put on the receipt of funds is going to listing broker. You don't have to get a trust account number for the listing broker. They're not going to give it to you, but that's enough. We know where it's going. So it used to be not that difficult for a client to get a certified check. And for me, a certified check is better because it has the client name on it, it's got the account, and it's certified. So it's clear the money came from the client. The problem is now banks are more and more not wanting to give certified checks. They want to give bank drafts. And as you know, a bank draft doesn't say anything where the money came from. It just says money. And so the government is suspicious about this. So you're supposed to ask the client, can you give me the number and name on the account where this bank draft came from? And some brokerages are actually asking the buyer to get, you know, you can get one of those bank statements that shows your name and the account information. It's like a form. They're asking the client to go to the bank and get that, and some clients are doing that. Now, a buyer asked me, do I have to give this information to my bank or to my brokerage? And I said, they really can't force you to give the information, but I understand why they're asking. They want some proof that the money came from you and not from somebody. In my opinion, you have to ask the question. You have to ask, did money come from your account? Every time. And if they say yes, you write, client verifies, client confirms money from their account. That's enough. Because what does it mean? You asked the question. You don't have to be a detective, just like me. I don't go do a search to see if a person has ever owned another property anywhere across Canada. I don't do a search. I just ask them, have you ever owned a house? No? Sign here. That's what you're doing. Did this money come from your account? I verify. That's enough. You ask the question. Yes, I'll try to leave the questions to when I finish the Fintrac. We'll do a few questions at the end, okay? So, as I said earlier, you want to identify somebody in person wherever possible. Sometimes you're going to have a client who, for privacy or other concerns, they don't trust you to give you the information. They're very nervous about personal information. They hear about hacking. They hear about identity theft. Does this mean you cannot act for these people? My answer would be no. In all of these situations, I would immediately get in touch with the person who's going to be their lawyer. And you ask the lawyer, I need you to identify this person for us. And 9 times out of 10, the lawyer will do this. I mean, I identify every buyer for the bank. The bank needs me to identify. So I have to do that. Why wouldn't I do that for a realtor? I would just explain, I have to identify you because the realtor has to follow the government rules. And so that's what you do when the client, for whatever reason, is nervous about giving you ID. It doesn't mean it's suspicious. They could have legitimate reasons for not wanting to show you the ID. You see, and this is what I have to do if the client is not in front of me, but is in another country. So, whenever a client calls me, they're buying, I say, when's the deal closing? They say April 30th. Okay, we'll sign the papers up probably the 23rd to the 25th. And so they say, well, I'm not going to be here. I'm going to be leaving town in April the 10th, and I'm not coming back till after closing. So then they'll say, can I sign a power of attorney? And really, lawyers hate using powers of attorney. Title insurance companies make you a lot of grief with powers of attorney because they've been the source of fraud. So what I say to the person is, if you're going to be here to sign a power of attorney, why don't you just sign the closing papers? And what we'll do is we'll prepare the closing papers quickly, get the client to sign everything before they leave, and then they can go away and not worry about the closing. But sometimes the client's not going to be here. They're not here now. And so they're in another country. So if they're in another country, I've got to get somebody to identify them for me. So for me, the only people I trust are lawyers or notaries in another country. I don't trust anybody else because I have to make sure that this person was a proper professional and that they identified this person and then they sent it to me that they identified this person. That satisfies me. And that should be your criteria. Sometimes you will act for somebody overseas who you will not meet in person. So right away to the government, that's suspicious. It may not be your fault, but they're not in front of you. So it's potentially suspicious. So how do you overcome that? Well, they have this mandatory agreement. This is an agreement you sign with somebody in another country that says they will identify the person for you. So think about what I just said. You know, if the government comes and says, you know, how do you protect yourself to know when you're dealing with somebody overseas? We get a lawyer who's registered to identify this person for us and send it to us. And so to me, that's what you should do. Ask them to go to a lawyer, to go to a notary, identify them for you, send the paperwork here, you put it in the file. That's how you record the information and reduce the potential suspicion, just by doing that. You know that if the deposit is coming from somebody else, like the parents, you're supposed to identify them. You know this already. So that's why you ask the question, who's paying the deposit? Now we come to occupation. So the government, as I said earlier, this is why you want to send out that questionnaire. This is what the government cares about, because the answer to this question, in most cases, demonstrates that your client has a connection to this country and the community. So that's why they say that sales, self-employed, small business, these are not good occupations. It says nothing about the person. But if they're a doctor, a lawyer, a teacher, that's better. And so you want to be as exact as possible. Say what they do for a living. They're a human resources manager, put the company name. The more detail you have, it just shows you care about the person. And it definitely shows a connection to the community. People ask me about the word retired. Retired is okay, but you should put in what they did before. Retired school teacher, retired foreman, put the name of the company. There's nothing wrong with retired homemaker. These are all good answers because they show a connection to the community. This is how you get close to somebody. You're interested about what they do for a living, so it should be easy for you to get this information. You should know this before you even fill out the form. You're not allowed to identify somebody by Skype. So this is why when I go to somebody's house, I have somebody go to the house and have them sign in front of them. I can't do this, via Skype. Oh, just sign the papers and send them back. I'm not allowed to do that. And you can't do that either. You need somebody in another country to do the identification for you. And I believe it should be a lawyer or a notary because they have more official status. It's a better explanation for you. Third parties. So the third party section is section B. And this is a concern for the government because they're nervous if you're doing the deal with somebody who's really not the buyer, they're acting for somebody else. That's suspicious. And so again, you're not a detective. What do you say to everybody? You say, are you doing this deal for somebody else? And the answer will be 95% no. You put an X in no under third party. That you ask the question, you're not doing this for somebody else, no. This is the kind of stuff I have to do with every buyer now on closing. Is this going to be your principal residence or a rental? I have to put that in the system. If it's a rental, it goes right to CRA, then they're looking for the rent every year on your income tax. That's why we do this. They make us do this. I have to ask the client these questions when they close a buyer real estate deal. And so you have to ask everybody. Money came from your account? Nobody else? You're doing this deal for yourself, not for a third party. No. That to me is all they expect you to do. You're not a detective. That's all you have to do. With a corporation, that's a limited company that owns property, there's two things you have to worry about. The first is, what's the name of the company? Is it a legitimate company? And who can sign for the company? So you have to personally identify the person who was authorized to sign for the company. You want to get paid, so you need to know that the person signing for the company has authority. So, in my experience, most people with corporations, they do not have up-to-date minute books. It's the minute books that really say who can sign for the company. But they do have articles of incorporation, which has the proper name of the company and the address and the name and address of the directors. So as long as you have that with the proper name and one of the original directors signing for the company, that's enough. You identify the director. But you're still not finished. You have to ask this person, do you own all the shares of this company? And 9 times out of 10, the person will say, yes, I own all the shares. But if they tell you, no, someone else owns 50% of the shares. The rule is, anybody who owns 25% or more of the shares, you have to show their name and address on the form. You don't have to identify. You just have to show their name and address. And so, many times they'll just say, I own all the shares. That's enough. You're not a detective. You don't have to go searching in the minute book. You just have to ask the question. If it's a builder deal, and you're taking the buyer in, and they're giving the money to the builder or to the lawyer for the builder, most of the time it's for the lawyer of the builder, you do not have to do a receipt of funds. And this is why builder brokerages will take a passport and all those checks from the client. You see, the checks demonstrate that the money came from a Canadian account, and they have the passport of the buyer. So you see, this is why the builder brokerages do it this way. They want checks. They want proof the money came from your bank account. Now we come to powers of attorney. Although I said that they don't like powers of attorney, sometimes you have no choice but to use them. So there's two kinds of powers of attorney. One, when somebody comes to sign a will, the lawyer will typically say, I'll typically say to somebody, you should also sign a power of attorney now, because if in the future you're not able to make decisions, you want to make sure you appoint somebody who can do that. And we usually suggest either a spouse or a child. If there's an over 18 child, that's the person who should be the power of attorney. So you could have a situation today where somebody's in a retirement home, they can't make decisions, and they've appointed their child to be their power of attorney. You could have another situation where you have a husband and wife that own a property. The husband is going out of town. You expect offers tomorrow, and the husband is not going to be near a computer where they could sign. And so what they do is they give a power of attorney to their spouse to sign for them. How many of you have sort of seen those powers of attorney? So you see there's two kinds of powers of attorney, and you have to handle them a little bit differently. So first you want to see the original power of attorney before you do anything. And if you're suspicious about anything, send it to a lawyer first. Because whenever I'm acting for somebody with a power of attorney, the title insurance company is going to make me sign a 3-page story about this power of attorney. So I need to know that it's legitimate, because they won't let the deal close unless it's legitimate. So you're going to identify the attorney. So let's say the seller's in a retirement home, and they've given a power of attorney, they can't sign anything, they've given their son. The son you identify, that's the attorney. And you show the person in the retirement home as the third party. So they don't have to give you any ID. You just show them as the third party. The attorney is your client. However, let's say it's the husband who's gone out of town. You know that that husband will have input in the decision. He just may not be able to sign it. So in my opinion, in that case, you should also identify the husband. Even though they're the third party, they should be identified because you know they're going to have input. So in that case, if the property's in two names, husband and wife, and an offer comes in and the husband has given power of attorney to the wife, what you will do then is the wife will sign twice on the offer. So the wife will sign under her name, and under the husband name, you will put his name by his attorney, her name, she signs twice. So she signs once for herself, once as attorney for the husband. Check to make sure the power of attorney was prepared by a lawyer. If it wasn't prepared by a lawyer, the title insurance company is going to be suspicious, and this deal may not close. And so that's why I say look at the power of attorney right away. Many times, sellers, the agents, will send me the power of attorney. I say, send it to me. Let me see if my title insurance company would have a problem with this power of attorney. And I send it to them. And I say, what do you think? And they'll tell me, no, this will be acceptable. Then I know we can close the deal with this power of attorney. It should also have two witnesses. So if your power of attorney only has one witness, it's likely not valid. And you need to know this right away. You don't want to find this out the day before closing, that there's something wrong with the power of attorney. With an estate, it means somebody's passed away, and there's trustees now. So the trustee is your client. That's the person appointed to carry out the wishes of the person who's passed away. That's the person you identify. And you show the deceased as the third party. So the person who passed away is the third party. So you're going to ask for a copy of the will to prove this, and ask if there has been probate. And probate is the court process to get the will blessed by the courts. And sometimes it takes 2 to 3 months, sometimes it can take longer. If the probate has been obtained, then the deal can go faster. Sometimes a property can be sold without probate, but that depends on where it was registered and how long the family has owned the place. You should contact the lawyer for the family to find out if you can sell a property without probate. So, as a bit of a summary, What are some suspicious transactions? Cash deposits. The client is not in front of you. Remember, if the client's in front of you with ID, you're 95% of the way there. The name of the buyer is changed at the last minute with no well, I'm going to change it to my brother, who you've never met. That's suspicious. There may be a good explanation, but that's suspicious. Multiple deposits, assignments, acting for a third party who's not here. That's why you're going to ask everybody, are you acting for somebody else? Their employment does not add up. Their income does not add up to what they're buying. I gave you the example of putting down a big deposit, canceling the deal, and getting the money back. They don't want to provide you ID in person, they want to fax it to you. I don't trust anybody who doesn't have ID on them. They don't have anything in there, because I don't know how you can leave the house without a driver's license. And it all comes back to what I said earlier, how were they referred to you? Because most of the time, that question, how did you find me? That's the answer to Fintrac. You know their connection, you know how they're in the community, and the rest is easy. Okay, does that make sense to you? Does this help you with understanding why we do what we do, why we complete the forms, and the questions to ask? Okay, are there any questions on Fintrac? Yes, could you speak louder?
For residential or commercial leases, do you need Fintrac?
For residential leases, you do not need to do a Fintrac on somebody. For a sale of a business, if it does not include real estate, you do not need to Fintrac. My personal view is everybody should be Fintrac. But that's my view. I mean, nobody walks into my office, it doesn't matter what they do without us identifying them, but you don't have to for a lease or for the purchase or sale of a business. Okay, our next topic that I promised is updates to residential tenancies. And everything I'm saying is in your material that you have. So as you know, the government just issued a new form. Have any of you seen the new government lease? How many of you seen it online? What is the thing you notice about that lease if you read through it? What is the thing that strikes you right away? Anybody?
Very little protection for the landlord.
It's very short. And I spoke to 600 investors, people who own residential units. They had their annual conference, so I spoke. And they 100% hated the new standard formula. And do you know why? Because it didn't include all their illegal clauses that they have in their existing leases. That's why. You see, most leases that are there today are not legal. Example, you have to pay $100 NSF check fee. Not legal, you only have to pay 20 bucks. You have to pay the first $100 in repairs if you're a tenant. That's not legal. The landlord is supposed to pay for repairs. And so you see, landlords have been getting away with this for a long time. But under this form, none of these clauses are in there. And that's why landlords hate it. And so the law says you must use this after April 3rd. But when you see the penalties, not quite truce, but you see there will be changes. Because right now, the AREA and TREB offered a lease says something like this. If the parties don't sign a lease, then this agreement to lease becomes the lease. And for a lot of people, that is their lease. And it's a legitimate one-year lease. Well, that doesn't mention the government lease. And so AREA has already said that this form is going to be fixed before April 30th. And what they're going to say is something like this. The parties agree to sign the standard form lease using the terms of this agreement to lease. So then what you would have to do is take the rent and all the other terms of the agreement to lease and just put them in the new government lease. That is what you could do, or you could just fill out the government lease and sign it right away. So you could be faced with two of those things. after April 30th. And it'll depend what agents are comfortable doing. So now let's look at the penalties. So after April 30th, let's say you used your old form of lease with the tenant. The tenant can say, I want the new lease. And if the landlord doesn't give him a new lease to sign on the right form, then the tenant can hold back 1 month rent. In addition, the tenant can cancel the lease on 60 days notice. So even if the tenant has signed a landlord form 1-year lease, if the landlord doesn't give him the new, or her, the new government lease, the tenant can cancel on 60 days notice. So when I said this to the investors, they said to me, you mean we can use our illegal lease? And unless the tenant asks for the new one, we don't have to give it. I said, that's right. They said, terrific. They all applauded, they were so happy. But you see, in your world, you may not have that opportunity because the buyer agent might bring in, or the tenant agent might bring in an offer that says the parties will sign the government lease. Or they may bring in the government lease. So then the question is, are you allowed to add clauses to the government lease? And the answer is yes. And so I did bring my up-to-date landlord guide with me in case anybody wants to pick it up after I finish. It has the new lease plus all the clauses, but I've given you some already today. This is the no smoking clause that I recommend go in every lease. So this clause includes cigarettes, marijuana, and electronic cigarettes. It also includes no growing of marijuana plants because as of July, a tenant is going to be able to grow up to 4 plants. So with this clause, it's legal. You can attach this to the new government lease. It's not illegal. It'll be easier to evict if the tenant smokes marijuana after July 1st. You still will have to prove the tenant is bothering other tenants or damaging the place, but it will be easier if this clause is there. Another clause, first and last month's rent. The government lease only says you can take last month's rent. In my opinion, you should put in a clause that says both months will be paid at the time of acceptance by the landlord because you need the second month's rent to pay your HST on the lease, on the commission. 1 month's rent is not enough to pay the commission, and so this will be already say at the time of acceptance by the landlord, and that helps to get around the government. So people ask me, can the tenant offer a year's rent in advance? That's happening a lot in the GTA. And the answer is, if the landlord asks for a year's rent, it's not legal. If the tenant offers a year's rent, it's legal. But it's better be clear that there's no text or email from the landlord or the agent saying, you better think about upfront rent, because then it's not legal. And so you have to think about the buyer or the tenant in most cases. And is this person likely to put the money up and then go to the board to ask for it back? And make sure, in most cases the tenant is not going to do that. But the main thing is you can't have anything in writing that says you asked for the money up front, because then it's illegal. So you have to be extremely careful about that. The most you can raise the rent this year, 1.8%. And this has led to wars because landlords are upset about under-market rents and they're looking for ways to trick the tenants. And right now, the only available way to end the tenancy is the family reason, which means you give 60 days notice at the end of the lease and you put your child or your parent or your spouse in the unit. Well, the government changed the rules last year. Now you have to pay 1 month's notice as compensation. So if you're doing this, if you want the unit back from the tenant, you have to pay the tenant an extra month's rent in compensation, and the family member must occupy the place for 12 months from the eviction, or else the fine is $25,000 for an individual. If that's what you have to pay as a fine. And so this now is one of the #1 reasons of evictions at the landlord and tenant board. And the reason is many landlords are trying to trick tenants into leaving because then they hope to fix the place up and either sell it, because it's easier to sell without a tenant, or rent it to somebody else. So this is a war at the landlord and tenant board, and judges are looking very carefully at this reason to see, is it really good faith or just a trick? What happened on Saturday was and this is why I have to go down to BNN today. There is another eviction notice where a landlord is substantially renovating. And the law says you have to give the tenants 120 days notice, pay 3 months rent as compensation, but the tenants have the right to come back if they let you know they want to come back. So this was a downtown property, everybody's 8-plex, everybody's paying $1,000 a month. Done. The landlord gives them this notice, clears the building, spends a year and a half renovating it completely, and then pre-rents it to 8 people, $4,000 a month each. And he puts them in. Now the other tenants who left come back and say, we want to be in here. We told you we were coming back. And so they got a lawyer and they went to the board. And the board said, we understand, but we have no power to kick those 8 people out. Do you understand? The 8 people paying $4,000 a month are in there paying rent, and the board doesn't have the power to kick them out. So of course everybody writes what a disaster, loophole, people abusing the act, and what's going to happen now. And that's why they've asked me to come to speak. I have an interview at BNN after I leave here this morning to talk about it. And really, they're going to ask me, should the government change the law? Because right away the tenant counselors are all running, oh, this is terrible, change the law, change the law, change the law. And whenever the government tries to change the law, they make it worse anyway. And so, in me, first of all, I think that these owners could be subject to a penalty. This was complete bad faith. This case is not over. And the fine for a corporation is $100,000 for every violation. That's the maximum fine. So it's possible. A judge could fine this corporation a lot of money if they find that they acted in bad faith. So how is this going to affect the future? Everybody's going to try this nonsense now. Give somebody 120 days notice, and then pre-rent it to somebody else at more rent, and then tell everybody, drop dead, I can't kick this person out. But I think that what's going to happen now is judges who hear these cases are going to really study hard and try to see, is this really good faith or is it a trick? And they may make provisions to prevent this from happening in the future. So I don't think this really needs a change in the law. It's sort of like a one-off thing that happened. Okay. Where it's going to affect you is if you have a house with a tenant or a condo with a tenant and you got to sell it. And you can't kick the tenant out because the only way to kick them out is the family reason. So you have 2 choices with a buyer. The buyer can either assume the tenant, buy the investment, assume the tenant, or they can move in themselves. And if they're legitimately in good faith moving in, then you're allowed to do that. So if they're moving in, the good news is there's no penalty. You have to pay the tenant. You still have to give the tenant 60 days notice. They got to be on a monthly lease. And then you set your closing date. So even though it's March 27th and it's pretty tight, if you gave the tenant notice today, you could actually terminate the lease on May 31st. So you could set the closing date for May 31st or June 30th. It doesn't matter. And then you need a proper clause. So I've given you the clause to use if you're in this situation. So this also comes from my landlord guide. I've given it to you in the material. And what the clause says is the buyer will be moving in on closing. They will stay for 1 year after closing. Because if they don't, the tenant can bring an action against the seller to pay that $25,000 penalty. And I also put in that there'll be a 30-day extension if the tenant doesn't leave. And then you really have to work with a lawyer that understands this to make sure your deal closes. So let's say you did that today, and you signed the deal today, and let's say it was closing June 30th. So you put the termination date June 30th, closing date June 30th, we gotta make sure the deal closes June 30th. So what I would tell you to do is at the end of April, I would say go talk to the tenant. And if you see the tenant tells you, yes, I found a place, I'm moving, I'm leaving, great, the deal's gonna close, we don't have to do anything. But if the tenant tells you, I don't believe you, this is a trick, the buyer is not moving in, they're gonna fix it up and rent to somebody else, I'm not going anywhere. Well, then you see you can't wait till June 30th. What we would do is we'd get a paralegal to go to the board early, like at the end of May, and the buyer and seller and the tenant would go to the board. And I had this last summer, and we got the judge in both cases to say the tenancy will end on whatever it is, June 30th. So now we had a court order. You can't end the tenancy earlier than it's supposed to. But that way we had a court order, and in both cases, the tenant left on June 30th. Had the tenant not left, the 30-day extension would have given us the opportunity to get the sheriff, because only the sheriff can physically remove a tenant from the property. So you really need to be working with a lawyer that understands this. My advice always is, pay the tenant to leave. But that's easier said than done, paying the tenant, because it's better to find the tenant another place to live. So people ask me, how much do we pay the tenant? I used to say, pay the tenant the difference in rent for 1 year that they have to pay elsewhere, plus the moving cost. Now it seems the number is $130,000. I guess that didn't blow over well. That was supposed to be a joke. Okay, anyway. So, with residential, be very careful about renewals. Don't give rights of renewals in leases because you could make a mistake. So as an example, if you put this in a lease, that the tenant has the right to renew the lease on the same terms, that means the tenant gets automatic renewals forever, and they never have to go. So you can never put this in a lease. I'm going to take this clause out of the deck before I send it to you because it's wrong. This is a correct right of renewal because it allows you to raise the rent and it only gives one renewal. But my advice is don't use any renewals because you're liable to make a mistake. Sign a 1-year lease, let it go month to month afterwards, or you can always sign another 1-year lease at that time. Finally, be careful about occupying after closing. So what do I mean by this, occupying after closing? I had people come to me, they sold their house, I didn't act for them. So they came to me in July and said, we closed our house in April, sorry. And our new house wasn't going to be ready till August 10th. So the buyers let us stay in our house for 4 months. We made a deal that we could stay in our house for 4 months. We just got a letter from the builder, our new house won't be ready until September 15th. For us to move out August 31st and store our furniture and hotels, it's going to cost us $10,000. Is there anything we can do? So I said, let me see your contract. And they showed me their contract, and their contract says, seller agrees to lease back the property from the buyer for 4 months, ending August 31st, 2018. So 17, this was last summer. So I said, you're a tenant. And after 4 months, what does your lease become? Monthly. So just send a letter to the buyer saying, we're giving you our notice, 60 days, we're leaving September 3rd. Well, the buyers had a fit. I said, let them speak to their lawyer. There was nothing they could do, even though the buyers had made plans to move in. So, if you're ever thinking of doing this, this is the language you have to put. The parties agree the seller can remain on the property as a licensee only, under a license to occupy, which means they're the same as a guest in a motel, for a period not to exceed 4 months. It can't be more than 4 months. And the seller will have no rights as a tenant under the Residential Tenancies Act. Had this been in the client's contract, the buyers would have been able to come in August 31st and change the locks, because that's what that means, because you're not a tenant. And so, my advice, don't let sellers stay, don't let buyers in before closing. You're just asking for trouble anyways, but if you're going to do it, if you have to do it, that's the language that you're going to use. Okay, before I just spend the last couple of minutes, how many of you found that helpful on residential tenants? Thank you. And I apologize that I only have like a couple of minutes because I have to go to the interview, but if you want to pick up one of these, I have a few here, but I can only take 20 bucks in cash. I don't have my machine. So even though I don't like cash, that's the only way I can do it. Okay, I want to spend a few minutes here. This is a preview of my session at Realtor West at the end of May. So, you'll see in the lower right-hand corner where it says store, that's how you go through GeoWarehouse to buy the title search. It'll cost you $30 to $40 to do this. And this is what you'll see at the top of the page. So the top line, I'm going to come back to, it's the legal description. Where the arrow is pointing is the proper name of the owner. That's the name with the arrow, that goes on your listing. Sometimes the owner has changed their name, maiden to married, married to maiden. You put the name where the arrow is. It'll be easier to do the deed on closing. And on the other side of the arrow, it says whether it's joint tenants or tenants in common. And so that'll give you a hint. If it's joint tenants and somebody's passed away, you know that it's only one owner that now owns the property. Just above, you see it says fee simple absolute. That's above the arrow. If it says fee simple absolute, you must get probate. The property cannot be sold without probate. If it says something called fee simple conversion, then it's possible to sell the land without probate. That's why I just need 30 seconds and I can tell whether property can be sold with or without probate. It's right from the title search. Now, you can do mortgage verification. So further down the page, I know it's a little bit hard to see, but where the arrow's pointing is the original principal of any mortgage. This says $250,000, TD Bank. If it has two mortgages, it'll show right on the page. So right away, before you meet the seller, you can find out a little bit, will there be enough money to close this deal? Are there liens on title? So I'm starting to see tax liens to the Canada Revenue Agency. And all you're going to see on title is lien, Minister of National Revenue. They don't tell you how much is owing, but when you go into the seller, you have to say to the seller, it says on your title you owe money for taxes. This will have to be paid on or before closing. So if I'm the lawyer for the seller, I have to send faxes to CRA. They tell me how much is owing, and I got to pay it right out of the closing proceeds with the mortgage. I got to pay those things off. So you got to find out, is there going to be enough money to pay the mortgage, the taxes, and left over to pay your commission. Now we go back to the legal description. So this is an example of a legal description, and it says, Lot 18, Plan 4323, ST. What does ST stand for? Anybody? What is the word, the letters ST? You see this a lot in legal descriptions on MCAP.
Subject to.
Very good. Subject to. This is not a good thing. So ST means somebody else has the right to come on this property. Now, if you look at that number, SC, it's on the page. Many times it'll say something like Bell Telephone Company of Canada, meaning that Bell has the right to come on the property to fix the wires, and most people accept that. When they buy a property, that Bell or the cable company or Hydro might have the right to come on the property to fix the wires. Sometimes it's not clear, and you have to get a copy of the instrument, and that costs usually $3 to $5. I recently did a deal in Toronto on Chaplin, which is on the ravine side of Chaplin. How many of you are familiar with that, the ravine side of Chaplin? So it had an ST in the legal description. So during the home inspection condition, the buyer said, can you check what the ST is? And it turned out the ST was the City of Toronto has a sewer easement along the 10 back feet of the rear of the property fronting onto the ravine. And so the buyer said to me, we want to build a shed back there, because there's no shed. And I said, well, you're building on land that is an easement to the city. They could come and make you tear it down. But they said to me, our neighbor has a shed there on the same easement because it runs across all the property. So I said, well, that doesn't mean that they can use it. It means they can use it, but the city could come and rip it down. And so they were okay with that, and they bought it. But you see, in another situation, that easement could stop somebody from building a swimming pool in the backyard. And it's very important for a buyer to know this before they sign any agreement. And it's not costly to get a copy of this. So as a listing agent, you want to make sure you disclose this. And as a buyer agent, you've got to ask, what does everybody else do? What is this? It's not that complicated to find out. Then you may see a notice on title. So most of the time, notices relate to things like furnace rental contracts. And because the finance company will register something against the property, and you'll know right away before you go there that there's a furnace rental contract, air conditioning rental contract. You can ask the seller right away, how much do you want this contract? Does it have to be paid off on closing? Because some of these contracts say they're not transferable to the buyer. They got to be paid on closing. If you see a CPL, certificate of pending litigation, it means somebody's suing somebody on the property. It ain't selling so fast. And so you may not know why this is the case, but you would want to talk to the seller about this. So I know I've rushed through this little portion, and it's going to be expanded realtor quest, but how many of you think this is good information to have when you go to try to get a listing? You see, to me, if you present all this stuff to the seller, number one, you could point out, oh, there's a private mortgage. That's going to have to be discharged on closing. You'll have to tell your lawyer about this. I see there's a furnace rental. Can you give me the contract so I can call them? You see, you're talking about real professionalism. To me, there's a big difference between that and I'll cut my commission. Do you understand? There's a big difference when you have that conversation with the seller and I'm cutting my commission. Do you understand? Okay, yes?
Good question for you. Could this be the same notice if it was a lien against the property?
A notice, well, lien usually says lien, if it's a lien. Notice could mean a bunch of different things, but usually there's an explanation with the notice what it means.